Because, Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
a no
Sir,
RV.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't object. You can appeal. Brother, why'd you just waste 5 minutes of my life?
All right, everyone. Today we're looking at a courtroom situation involving someone who believes the normal rules don't apply to him. He tries to challenge the judge using ideas that don't really match the law. But the judge isn't interested in arguments that aren't based on facts. He stays calm, sticks to the law, and deals with the situation in a very professional way. Watching this interaction is actually very interesting. The man keeps trying to push his points, while the judge patiently explains how the law really works. It's a good example of how patience and logic can handle difficult situations in court.
A motion filed?
Yeah, oh, yes, absolutely. I actually had issues to discuss before I crossed.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word that was since been signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front protect.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying to be
well, which one
dismissed.
do you want to start with first?
Well, the recent one I filed, the motion to reject swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting.
That's the only civil infraction.
I have numerous. I have lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket, because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets, it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my attorney.
Let me ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame to contact
Mr.
court.
Crucell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting.
Well, once again, I'm going to draw your attention.
One thing that always stands out in cases like this is how some people believe they can ignore legal rules, even though the legal system clearly doesn't work that way. Let me know what you think in the comments. Did the judge handle it perfectly, or could he have taken even stronger action? Let's get into the video. One thing that quickly becomes clear is that the man keeps talking instead of simply answering the judge's questions. The judge is trying to determine something very simple. whether the man knowingly missed his previous court date or if he honestly didn't realize he had one scheduled. It should be a straightforward conversation. But instead of giving a clear answer, the man keeps arguing and going off topic. Situations like this make the hearing longer than it needs to be.
My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the
Okay.
mail, but this was scheduled for March 8th.
Okay.
So that was even less than a
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
well, once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay,
There was no dates.
okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when we were in front of the Honorable Judge Martin. She did set aside the default on the civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir, do
aside.
not interrupt the lady. Did she interrupt you?
No,
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes,
Brother, why'd you just waste 5 minutes of my life?
since March 14th, Your Honor.
which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my motion.
Sometimes it's hard to tell if people truly misunderstand the process or if they believe their approach will somehow work in court. Either way, it doesn't help their case. Let's continue and see what happens next. Another interesting part is that the man actually received exactly what he requested during his earlier hearing. At that time, the previous judge decided to cancel the default decision after the man filed a motion asking for it. In other words, the court gave him the opportunity he asked for. Now he appears confused about the dates and the situation, even though the court already addressed the issue earlier. Cases like this can take a lot of time to sort out. Court hearings involve judges, staff, and resources that are all funded by taxpayers, so when arguments become unnecessarily complicated, it slows down the entire process.
And I object to this.
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatening to come in and pay money or warrants. would
How
be
was that
issued for my
damage?
arrest. And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money or they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to
Stop.
me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside that there's no issues. with
She
the
didn't try to
court.
set it aside. She sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside. She set a default aside because you asked her to.
Well, so if it's decided, then the money should be returned, correct?
Well, I don't know. Did she address the money?
I don't
No,
think so.
she never did. No one did. It's
Sir-
written in my motion.
Sir, I'm going to hold you in contempt the next time you cut her off.
What do you think so far? Should judges continue giving people chances to explain themselves, or should they move more quickly when the arguments don't relate to the law? Let's keep watching. In this next moment, the judge takes control of the situation. Looking back at the clip, it may have been slightly unclear at first whether the judge was speaking directly to the man. However, once it became obvious, the man continued speaking over the judge instead of listening. When someone represents themselves in court, it becomes even more important to stay focused and respectful. Clear communication helps the judge understand the situation and move the hearing forward. When the conversation turns into constant interruptions, it only makes things more difficult. Fortunately, the judge steps in and brings the discussion back on track. Let's see if things improve from here. To be fair, one of the man's arguments is somewhat different from the usual claims we often hear in similar cases.
The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At
care
some
of.
point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
absolutely.
Okay, hold on. I denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of my motion.
object. You can appeal.
Well, I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
telling
nothing
you.
to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station and we in town, and we had, or in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it and went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me, and wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference of opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated,
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for.
Instead of discussing complicated legal theories, he says that some officers told him it was acceptable to drive, while the officer who issued the ticket believed it was not allowed. That explanation is at least a practical point to raise. It suggests there may have been confusion about what he was told. However, even if someone receives mixed messages, the law itself still determines what is allowed. For example, if a person is carrying something that legally requires a permit or license, the law may require them to disclose that information. In addition, having a valid driver's license is also necessary. So the key question becomes whether the legal requirements were followed. Do you think his explanation sounds believable? Or do you think it raises more questions? Let's continue and find out how the judge responds. At times during the hearing, the man seems to rely on information that may not come from official legal sources. Some people read guides or watch videos that claim certain strategies will work in court. These sources sometimes encourage people to represent themselves or challenge the process in ways that aren't actually supported by law.
So I'm going to let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no?
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
calling it
understand?
an
Sir,
ORV.
your objections mean shit to me, okay? I don't care what your...
This raises an interesting point about education. Many people don't learn much about everyday legal rules unless they study law or go through specific training, such as driver education. It might actually help if basic legal principles were explained more clearly during school, so people understand how courts and laws function in real life. Understanding the basics, such as driving laws, legal responsibilities, and how court procedures work, could prevent a lot of confusion later on. What do you think? Should schools spend more time teaching practical legal knowledge? Let me know your thoughts. In the end, the judge handles the hearing calmly and professionally. He listens, stays patient, and makes it clear that the law still applies no matter how many arguments are raised. That level of professionalism is important in a courtroom, especially when discussions become difficult. It can be frustrating to see court time used on arguments that don't change the legal facts. Every hearing involves staff, judges, and public resources, so keeping the process focused on the actual law is important.
Won't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care. All right. It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial, for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand
I don't think
that.
it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it's like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that as
Mr.
well.
Purcell, with
So
respect,
again,
with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
well,
right?
the officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on,
Or he had a difference of opinion about whether or not you were driving an ORV.
or just didn't understand the laws or
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions? At trial.
Well, honestly, in the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, and as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own
But sir,
recording.
stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right. Now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay. How many jury trials have you had?
none, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. Would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right.
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else?
Yeah.
Have a nice day.
One final point involves the driving issue mentioned earlier. If one officer gives advice and another officer later enforces the law differently, that doesn't automatically cancel the legal requirement. Officers may share opinions, but the written law ultimately determines what is allowed. If the required license or documentation isn't present, a ticket can still be issued. All right, everyone, that brings us to the end of this case. Let me know what you thought about the hearing. Do you think the judge handled the situation well? And what did you think about the man's arguments? Thanks for watching, and if you enjoy this type of courtroom breakdown, feel free to like and subscribe for more discussions like this. Take care, everyone.